Thank you, Haiti. It's a great pleasure to be with you here in Helsinki to talk about cost allocation. Not the most scintillating topic, but one that I hope you'll find of some interest. There are two things we know about it for sure before we go further. One is that there's a lack of transparency in terms of what arbitral tribunals actually do about cost allocation or why they do it. And secondly, that there's not any agreement on what they ought to be doing. So how do we address those subjects? Here are some suggested approaches to cost allocation, 5 of them that you might consider. They're not all inconsistent. The American rule, I'm going to say something about each of these. Costs follow the event. A percentage allocation based on relative success, which one might think of as a modified costs follows the event principle. Then there's a possible checklist of other factors that one might consider in allocating costs. Finally, there's the idea that there should be incentives built into cost allocation for good conduct and sanctions for mischief. Is one approach best suited to international arbitration? You read occasionally articles saying that for some proposal or other should be favored in this area because it is best suited. So when I approach that question, I think about the following elements of international commercial arbitration. It's not a state court, so someone has got to pay for the system, not the taxpayers. Both sides agreed to this. It's in an arbitration clause. Obviously, a relevant principle is deterrence of frivolous claims, but, an important but, super deterrence of frivolous claims doesn't seem to me, at least, to be a widely perceived problem in commercial arbitration. Does all of that necessarily lead to any best approach? Well, I'm not sure it does, but insofar as one can generalize from those concerns, I would think they would direct you toward an instinct for some sharing of the cost of the system. Let's look at the American rule. It seems fair I can talk about that. Most people's ideas in international arbitration, when there isn't something expressly written, derive to one degree or another from their national court experience, and that is true here. In the American court system, the loser pays the court costs, but not the prevailing party's attorney's fees. And this goes back to an 1853 act of the U.S. Congress that codified this principle for federal courts, and it later followed everywhere in state courts. And the idea is that there are docketing fees, which are really quite small compared to the percentage of costs that arbitration administrative costs comprise. And it got courts out of the business of regulating lawyers' fees, because prior to that, many state systems prescribed maximum fees for particular acts of providing legal services. And it was decided back in 1853 that this was bad business. Legal administrators shouldn't be in that business, courts shouldn't be in that business. That was a matter between parties and their representatives. So here, this was a simplified way of doing it. And there are many statutory exceptions where attorney's fees can be awarded to a prevailing party. There's inherent power in a court to sanction misconduct by awarding costs and attorney's fees against a party. So it's not an either-or, all alternatives, everybody bears their own cost totally type of system. But it does separate, in principle, the idea of court costs being relatively small in comparison to the rest of the costs, your own costs for your attorney's fees. In arbitration, that's migrated a bit. So when people think of the American rule now, they normally are thinking of, yes, bear your own attorney's fees, but split the procedural costs, the administering institutions costs, the arbitrator's fees, on a 50-50 basis. And that seems to be the going starting point for arbitrators who are following what they think of, or whether they call it that or not, the American rule. And the reasons for this were historic, as I've said. There are also now cultural expectations built into it. The Supreme Court has described this as deeply rooted traditions, based on the idea that there is a reason to not discourage people having their day in court. Even though one side may prevail, it is not unusual for there to be two sides to the case, one which legitimately were presented, and it's not necessary or proper to punish people for trying out their case. So what about cost follows the event, the second approach here? It's a formula, or at least a presumption, of course, in favor of the loser pays. And again, as my understanding at least, is it derives from court traditions that have been carried over into arbitration. Of course, one wants to make the winner whole. That must be the driving principle behind it. But I would at least see in cost follows the event some other things operating. It obviously works to discourage frivolous litigation and presumably arbitration. It may encourage efficiency if you know that there's a risk that costs may be allocated. And I suspect it derives from a generalized notion that litigation is a bad thing. And so if we over-discourage it, that won't be the worst of all possible outcomes. And so that's where the rule comes from. So widely endorsed, you see it everywhere as listed as a starting point. Indeed, the FAI rules list it as the starting point for all of this. But what does it really mean? Loser pays, but not necessarily all, of course. That's what the reality is. Cost shifting, but with relative success being an important part of the apportionment principle. Other things go into it too, but you start by looking at relative success, which immediately leads you to the question of success as to what? Percentage of what? Do we just look at the amount of damages claimed and see what percent you've recovered? Do we consider counterclaims and say that they balance each other off, claims and counterclaims, and therefore we come to 50-50? What if one is the 2 million and the other is the 200 million? How do you count that in terms of success? Do you consider specific issues? Do you say that there was a predominant issue here and claimant prevailed on that, so he should get 75% of his costs and the other party should bear 25%. No particular formula there, no particular rationale either. It leaves it free to arbitrators to do what they consider just in the circumstance, but it leaves parties without much guidance as to what that might be in advance. So what is the actual current practice? We do have information being developed on this increasingly. The best, I think, is the ICC Commission's cost report that came out in December of 2015. And it's got a lot of information in it. It has an extensive appendix that reviews quite a few historic ICC arbitral awards to draw out patterns. And of course, it does say that the majority of the tribunals use loser pays as a starting point. But it goes on to say it is not uncommon, as are words in the report, to split the cost 50-50 based on relative success. So bow in the direction of loser pays and then say, but loser only pays half. So maybe not the prevailing majority outcome, but not uncommon, according to this survey. And also, it was found, it was not the predominant mode, but at least a number of the cases that the Commission reviewed found that tribunals did draw a distinction between arbitration costs and party legal costs. So in practice, although one thinks of all of this as costs as defined in the various rules and statutes, when they come down to it, it is not unusual, at least, if not the majority rule, to consider the two major components of costs on a separate basis. We also have some recent evidence from the Stockholm Chamber, a report on investor state disputes earlier this year. Now, this looks at investor state, which is in some ways different in terms of allocating costs because of the presence of a state party. But they found 42% of the tribunals split the costs, you guessed it, 50-50. Costs follow the event? Well, not really. And indeed, the Stockholm report used the term standard apportionment for a 50-50 split. So costs follows the event, the loser pays. Everybody says it, but who's actually doing it? The Stockholm report showed 58% deviated to some degree from 50-50, but significantly, not one of the awards they studied awarded all of the cost to one party. So that's cost follows the event in practice. But what else? Other factors. Many contend they should be considered. What are they? Should we have a list of the other factors so that at least if we don't know what weight's going to be given to them, we at least know a list of what they might be? Well, some people have actually set about listing such things, and I found one. This is Professor Arthur Rovine's 12 appropriate considerations, and this was in the context of investor-state arbitration, but I think you can generalize fairly broadly. And it gives you an idea of where all this goes once you start trying to make a list. First of all, he talks about good faith conduct, no fraud or abuse. All right, that seems uncontroversial. Over-lawyering, causing unnecessary delay. All right, that seems like something most of us could agree might be taken into consideration. Then reasonable level of cost, considering the size and complexity of the case. Did somebody just blow it all out of proportion? Well, I guess that makes sense. Reasonable level of costs in relation to the other party's costs. Well, that's one of the things that arbitrators sometimes look at in evaluating reasonableness, yes. Then our Professor Rovine says, was it a case of first impression? Now, this is beginning to sound like American thinking. Was it somehow justified in being brought even if you lost? And if not, was it a close case? Well, now we're getting into areas that's a little hard to evaluate. And the list goes on. Could crucial arguments or evidence have gone either way? Well, that sounds like another way of saying, was it a close case? But you could imagine most cases might have that factor in them. Which issues were won by each side? Well, as I've said, that's one of the things you could look at. And of course, what percentage of the claim? Those are the traditional measures. And then he goes on to say, and maybe this is unique to investor state, but maybe not, which party has more financial resources? You can sense lurking in that the question of whether it seems just at the end of the day to add on charges to a small party with meager resources who may have been outlawyered by the other side. Does the governing law provide guidance? Well, it's kind of low on the list to be asking that. Usually the answer is going to be not much. Did any of the foregoing have an important effect on costs? Well, I guess so. Otherwise, we probably wouldn't be looking at them. So if you're making a list, does it really provide a lot of guidance? You can do it, but does it tell you much more than the obvious? So here's a question. Are we really trying to serve too many masters when we worry about a formula or an approach for cost allocation? We have proposals that deal with ex ante steps, things you do at an early stage in the proceeding or in the rules to deter bad conduct and encourage good acting. Then you have rules that would apply ex post, things that you do or say you're going to do to punish bad conduct. Then you have other aspects that come into it. Is it just sometimes to mitigate a harsh merits result? Again, Arthur Rovine's cost ability to pay of the parties maybe being a relevant consideration. If someone has lost a large amount of money, is it fair to hit them with millions of dollars of the other side's attorney's fees too, or is that somehow too much? And finally, there's the consideration that it would be nice if we knew more about all of this. It would be beneficial if arbitrators articulated their reasons and provided precedent. So all of those are worthwhile things to think about, but how does it really work out? And here's the fifth approach on my list, which is incentives. So here are suggested techniques for encouragement of good conduct, discussions or warning at the outset of the case about costs. Now, the ICC proposal suggests some language that might go into procedural order number 1 about how you're going to take conduct into consideration. My submission is that boilerplate isn't going to make much difference. You could put that in with the other 23 boilerplate clauses that go into your advance warnings. Or you could be draconian. You could sit down with everyone at the first procedural conference and you say, now, remember, I'm going to expect good conduct from all of you, and I'm going to punish bad conduct, so be on guard. I don't think that's a smart thing to do either. You could announce the intention more generally to make interim costs awards after various procedural stages. Again, do you say that just as a matter of boilerplate, or do you say that shaking your finger at them? You could put changes in arbitral rules that said something about mandatory cost allocation as sanctions. You could even think about cost budgeting. This is something that I've read is being done now in English courts. The English Civil Procedure Rules require detailed calculations, this is for cases up to 10 million pounds, of what the costs will be for various stages of the procedure, the disclosures, witness statements, expert reports, and so forth. And this all gets reviewed with the court and established as kind of a budget in advance. It's been suggested one might do something like this in arbitration. Not yet, but it's been suggested. On the other side of the coin, punishment for bad conduct. Well, you could have, as might be warned in advance, cost determinations after each phase of the case. You could have identification of specific unnecessary procedures or uncooperative actions or unreasonable cost levels that you might try to impose. All of that puts a big burden on the process. Do you really want an arbitral process that we're trying to make less costly and less time-consuming, something that goes this far into the purported regulation of costs? And just to show how far it can go, we have one recent example from an ICSID case, in March of this year involving the government of Uzbekistan. And the arbitrators opposed a sanction of $380,000 for failure to protect the identity of the experts. One side accidentally leaked the identity of the experts, and the expert withdrew his report. So the expert fees were imposed as a cost for violating confidentiality. You can see ways in which cost allocation might be used, but does any of this really lead you to some sort of formula or list of considerations that will deal with this in some way that will lessen confusion and provide more flexibility? Well, maybe not, but I do propose a simple solution, or at least a framework for looking at all this. We're never going to come to an agreement on a formula that always works, but my proposal, at least, and this is perhaps a modified American approach to all of this, is first to consider the arbitration costs and the party costs as separate items so that you have two variables in play that the arbitrators can consider allocating. And you use each of those to police a particular sphere. Use arbitration costs to reflect degree of success. Arbitration costs are not small. They're not trivial. They're not the docketing fees of the American court system. They do include the arbitrator's fees. And here we're talking dozens of thousands or hundreds of thousands of dollars. And if you think it's important that costs follow the event, or at least that we honor that principle, here's an easy way to do it. Party costs, on the other hand, may run into millions. And here, arbitrators in practice, it would appear, are more cautious about leaping to say that the loser should pay all of them. They can be used to sanction inappropriate conduct, I would say, but should be considered separately rather than simply lumped in with percentage of success and imposed. And here's my list of potential advantages to all of this. It's at least a framework without any attempt at rigidity or a formula. Separating the two aspects does appear to correspond at least somewhat with what we see in actual arbitral practice. It avoids the adding insult to injury factor by avoiding automatically imposing the opponent's legal fees on the loser, again, in a situation where a loser may be a kind of rough idea when someone has not prevailed on everything. It tends to avoid the contentions over the reasonableness of legal fees. This was the reason that the American court system got regulators and courts out of the business of passing on legal fees adequacy in most situations. And I think arbitrators are generally somewhat uncomfortable with having that role as well. It's a little hard to look at fees that have been charged and in most instances paid by clients and then try to tell them after it's all done that you consider it unreasonable. And, in my view, it leaves costs to the case end, which is where I think they should best be considered, and avoids any early frictions of trying to deal with all this in advance. So finally, is there a universally applicable, simple solution to all this? No, I don't think so. But I think we could try to find a simplified framework to deal with all this, and I've at least offered one. And I think there's a good reason we should try to keep it simple. Thank you.